All right, we're recording.
Great. Thanks, Mia. So welcome to our second Paid Family 101 training, and I'm going to pass it to Naisha to do some introductions.
Hi, everyone. Some of you know me as program coordinator for the Healthy Start team. And for those of you who don't know what Healthy Start is, we are a nonprofit that works to eliminate and work with communities, specifically Black communities, on the maternal mortality and infant mortality rate. So we decided to bring this training, paid family leave, because we know that there are many factors impacting that statistic, and one of them is not being able to have leave or understanding the rights around leave in the workplace. So we're really excited to have California Working Family Coalition do this training. I've already learned so much, so I hope you all get a chance to learn some new stuff today. And that's kind of it. Yeah. So welcome, everyone. If you didn't come to the first one, Charlotte did record the first one, and we'll be sending it out after all 3 series. So, don't worry, you're not missing anything. And we hope to see you in the third one. All right, I'll pass it back to Charlotte.
Thanks, Naisha. Thank you so much for inviting us to do this. Before we get started, go ahead and put your name, pronouns, organization, or workplace, or if you're an individual, you can state that if you're comfortable in the chat. We would love to get to know all of you and who is attending today. So yeah, go ahead and put that in the chat. And then for us, we are the California Work and Family Coalition. My name is Charlotte Flanders, pronouns she, her, hers, and I'm the Education and Training Manager. I'm going to pass it to Jenya.
Hey, everybody. Welcome. My name is Jenya Cassidy, and I'm the Director of the California Work and Family Coalition, and I will pass it to Katie.
Hi, everyone. Good morning. My name is Katie. My pronouns are she, her, and I'm the Political Organizing Director at the Coalition, and I will pass to Angelica.
Hi, everyone. I'm Angelica Andrade, and my pronouns are she, her, hers, and I am the Administrative Assistant and Spanish Training Coordinator at the Coalition, and I will pass it to Mia.
Hi, everyone. Good morning. My name is Mia Hemstad. I use she, her pronouns, and I'm the Communications Manager here at the Coalition. Great to be here.
And joining us today also is Aditi Fruitwalla, and I will let her introduce herself. Aditi?
Hello, everyone. Good morning. My name is Aditi Fruitwalla. I am a staff attorney with the ACLU of Southern California in the LGBTQ Gender Equity Reproductive Justice Projects, and my pronouns are she and her. And ACLU is an organization that has affiliates in all 50 states and Puerto Rico and DC, and then we have a national office in New York. Our purpose is to defend the fundamental rights in the US Constitution and Bill of Rights. And we have several issue areas, including First Amendment, equal protection, due process, privacy, and groups and individuals that continue to struggle for civil liberties. That's the way that we approach the work. And in particular, what we're doing here is that we also do gender equity, reproductive justice, and LGBTQ work.
Thanks, Aditi, and we're excited to have you here today with us. And I thought, Jenya, maybe if you'd want to introduce the coalition as the director.
Yeah, great. That was such a great introduction to ACLU. It's really, so ACLU is one member of the statewide California Work and Family Coalition, and we are a statewide alliance that came together around the first passage of the first paid leave bill, and we've been working together ever since to really expand the right to take time to care for yourself or care for your family. And we do it in a couple of main ways. One is policy change, trying to, really we've had a lot of success changing our policies so that more people can take the time they need. And also things like this, education and, how do we know our rights? Because it's not enough just to pass the policy. And I think at the end here soon we'll be sharing some links, because if people are interested in getting involved, even this week, Friday, we have a day where we're going to be visiting our policymakers about expanding our paid sick days law, for example. So really, I'm happy to be here with all of you. Thank you.
Should we skip this one, Jenya?
Yeah, you see this nice picture of us doing some of the things we talked about. Yeah, I kind of like ran into that part, but yeah, that's the second slide. Thank you.
No problem. I mean, it's a great picture, so.
Thanks, Jenna, for that great introduction. And for today, our training goals is that we're going to review the laws that we covered last week. We're going to learn about paid sick and safe days, and then apply what we learned to some scenarios that might help you understand how these laws work together. So for our agenda, we're going to start with the review, go into some practice scenarios, learn about paid sick and safe days, and then we have a paid leave checklist case study, and then a Q&A session again. So I'm going to pass it to Angelica to talk about paid family leave.
Thank you, Charlotte. So we're going to go like a little recap of what paid family leave is and disability insurance. So both paid family leave and disability insurance are a wage replacement program funded by the California State Disability Insurance Fund, which is funded through employee taxes, which are your taxes. Paid family leave and disability insurance are like two halves of a whole. In California, we have pay for when you can work if you are pregnant, disabled, caring for a family member, bonding with a new child, or dealing with a military exigency. For disability insurance, you would take this leave for your own sickness or pregnancy-related disability. And for paid family leave, it would be to prepare for a military exigency, bond with a new child, or care for an ill family member. So the basics of paid family leave and disability insurance, it is a 60% or 70% of normal weekly wages. So up to $1,357 per week starting July 1st, 2021 for up to 8 weeks. And the leave can be taken all at once or in parts, so hourly, daily, or weekly. And this is very, very important. The pay rate will decrease if no action is taken by the California administration and legislator. The pay rate for the paid family leave and disability insurance programs will decrease to 55% by January 1st, 2022, unless we advocate for it to stay the same or increase. And you can go to workfamilycalifornia.org/raise the rate to advocate to protect and increase the rate for paid family leave. The eligibility requirements for these programs are paying into the California State Disability Insurance Fund. So in this slide, you can see a picture of a pay stub, and it shows that this individual does pay into the state disability. And another eligibility requirement is that you are taking the time to bond with the new child, need to care for a seriously ill family member, need to care for your own illness or disability, or prepare for a military exigency. And the last requirement is to have earned at least 300 from which SDI deductions were withheld during the base period. And another important thing to remember is that citizenship and immigration status do not affect eligibility of paid family leave benefits and state disability insurance benefits. So a paid family leave is a wage replacement program only, so it does not require your employer to give you your job back when you return from leave. But Aditi will go into the job protection laws.
Excellent. Thanks for that, Angelica. So I'm going to be talking about job protection. When you need to take time off to care for a new baby or a sick family member, I think there's typically two things that people want to know. The first is, how much time can I take without being fired? And the second is, how much will I be paid when I take that time off? So Angelica just did a great job of covering that second question, how much will I be paid, which is 60% or 70% for 8 weeks. So now we're going to tackle the first question. Can you take time off, and how much time can you take before your employer is able to fire you, to discriminate against you, to retaliate against you. There are 3 laws that cover this: Family Medical Leave Act, FMLA, California Family Rights Act, Cifra, and Pregnancy Disability Leave, PDL. So many folks have heard of FMLA. I think we talk about that often when we talk about job protection and family leave. FMLA is the federal law that applies to everyone in the US. I think folks are unlikely to have heard of Cifra, CFRA, the California Family Rights Act. And it's the California law that only applies to people living and working within the state of California. It's mostly the same. Cifra and FMLA cover mostly the same issues and kind of are really run in parallel. And where they diverge, Cifra is actually more protective. So for this presentation, we're mostly going to talk about Cifra because all of you live and work in California. So eligibility requirements for Cifra. You are eligible to take this leave if you have worked in your job for 1 year, if you have worked 1,250 hours in the past year, and that is roughly 25 hours a week, and if you work at an employer with 5 or more employees. And you can take Cifra leave to bond with a newborn, a recently adopted child, or a foster child, to care for a seriously ill family member. And what family member is defined as children, spouses, domestic partner, parents, grandparents, parent-in-law, and siblings. We actually have a bill this year, AB 1041, that would add one more person to that definition called designated person. And so it would essentially allow all of us to take Cifra leave for one additional person that is like family to us, which is very exciting. You can also take Cifra leave to care for your own serious health condition and to specific situations related to military deployment of your child, parent, or spouse. Your rights under both FMLA and Cifra are that you have 12 weeks of job protected leave every year. You can take that time all at once or intermittently. So what that means is you could take, when you have a new baby, you could take 12 weeks all at once and have that be job protected, or you can take 3 weeks and then go back to work, and then 4 weeks and then go back to work. You are restored to the same or equivalent job. Your employer is required to continue your health benefits. So this is a really important one, that your employer cannot cancel your health insurance. They have to keep paying into your health insurance during this time. And you are protected from discrimination and retaliation. So for pregnancy disability leave, you are given up to 4 months unpaid job protected leave when you're disabled by pregnancy, childbirth, or related condition. So what that phrase means is that typically when someone is pregnant, they are not disabled by pregnancy throughout their entire pregnancy. It's typically for about 4 weeks before childbirth, but every pregnancy is different, and someone might be disabled for longer than that. And disabled just means that you can't do your job anymore because of your pregnancy. So this law gives you up to 4 months. And it has, it's certified by a doctor saying that that's the amount of time that you need. That's the amount of time that you're disabled by pregnancy. It applies to all employers with 5 or more employees. It can be used for prenatal care. So that's prenatal visits or, other types of care. It can be used intermittently, again, for, a few weeks at a time, a few days at a time. Your employer has to continue your health benefits. And for an uncomplicated pregnancy, your leave is typically 4 weeks before your due date and 6 to 8 weeks after the birth. And that 6 to 8 weeks typically is 6 weeks for a vaginal birth and 8 weeks for a C-section, though every birth, every person is different. So California also has really great, exciting lactation accommodation laws. If you are breastfeeding or chest feeding your baby, you need to pump every few hours, and you have the right to pump breast milk at work, and your employer has to provide you with lactation accommodations. So what lactation accommodations mean is that they have to give you a room that's private and not a bathroom. It has to be a separate room outside of the bathroom. It has to be close to your workstation. So your employer can't require you to go 3 buildings down to pump. It has to be basically close walking distance to your workstation. It has to be safe, clean, and free from hazardous materials. I actually have a case right now where the lactation room that the Navy gave this employee had roaches and had overflowing trash. And so one of our arguments is that that is not a clean room. It's not safe. It's not free of hazardous materials. It has to contain a place to sit and a surface to put your breast pump. And it has to have electricity so that you can plug in an electric pump. It also has to have access to a fridge or something to keep the milk cold, access to a sink so that you can clean yourself and the materials, and the policy must be written down. So as an employee, you should be able to request that policy from your employer and they can provide it to you in writing. If the employer has less than 50 employees, they can ask for an exemption to this law if it's an undue hardship. For most workplaces, it's not going to be an undue hardship because most office buildings, if that's where you work in an office building, they will have a room, like a conference room or something that can be designated as a temporary lactation room for people who need it. Temporary designations are okay. You can put sort of on the conference room, you can say, temporary lactation room. That's okay. It's not ideal, but it is compliant with the law as long as it also meets all of the other requirements of having, a fridge, having electricity, all of those other requirements. The other thing, just to note, that's really interesting about this law is that it has actually a specific provision for agricultural settings. So if you're a farm worker who works in an agricultural setting, your employer is required to provide you with a trailer to pump in. And I'm going to pass it back to Charlotte.
Thanks, Aditi, for all of that information. So now we're going to go into a couple scenarios. I know last week during our Q&A session, someone asked about how these laws work together. That's what we're going to talk about now. So the first scenario, this is Lennar. Lennar and his partner, Julia, are expecting a baby. He has worked for his employer for 7 years, works 30 hours per week, and has about 25 coworkers at his job. He looked at his pay stub and he pays into CASDI, and it is removed from his paycheck each pay period. So based on the information we know in the chat, go ahead with your best guess. Do you think that Lennar will qualify for bonding, and will he qualify for job protection? I see quite a few yeses. This is great. All right, let's see the answer. Yes, great job, everyone. So yes, and if you don't know, that is completely fine. There's a lot to know here, so we're still learning. So yes, he does qualify for paid family leave for bonding because he pays into the California State Disability Fund. He can take up to 8 weeks of paid family leave for bonding with his new baby and can receive 60 or 70% of his pay depending on his income. Yes, he qualifies for job protection under Cipra, so the California Rights Act, because 1, he needs to take leave to bond with a new baby. 2, he works for an employer for 5 plus employees. The third one is that he's worked at his job for more than 1 year. And then finally, he has worked for more than 1,250 hours within the past year. So he can take up to 12 weeks of job protected leave to bond with his baby. So again, the 3 eligibility requirements for Cifra. 1 year on the job, 25 hours a week, and then 5 or more employees. And then now let's see how all of these laws work together. So each scenario when you're working with parents, of course, it's in real life, it's very different, but we're just going to show you here how the laws look like and would work together. So this is a bonding parent, right? So Lennar, who is eligible for job protection and wage replacement. If you see the green line at the top, that's going to be our wage replacement, which will be paid family leave. The yellow line at the bottom will be the job protection. In this specific case, it will be Cifra. So if you see here, let's start with the job protection, right? So he can take 12 weeks of job protected time off with the continuation of health benefits. That is the unpaid part. But what makes it paid for the 8 weeks is the paid family leave that you see at the top. So for 8 weeks, he can take paid time off 60 or 70%. Now you see there's a little gap at the end. That's the 4 weeks. That is unpaid. And it's really up to the family and the parent. If you have the time that you can take the 4 weeks of unpaid week, you have that right to take it off. But you know, for many cases, just because the wage replacement rate is not high enough and people can't take time off with unpaid leave, people usually go back to work after 8 weeks or even sooner. So it really depends on the situation. So for our next scenario, this is Simone. So Simone is expecting her first baby. She has 10 coworkers. She has worked 20 hours per week. She has been at her current job for 1 year, and she checked her paycheck, and she does pay into the California disability insurance. So since she is a pregnant mama, we're going to see, does she qualify for pregnancy disability leave? Does she qualify for paid family leave for bonding? And does she qualify for job protection while on bonding? I know that's a lot. Any best guesses in the chat, feel free to put it in there. I know it's a lot, so no worries. Let's just go ahead and just talk about it. Oh, there we go. I see a lot of people. Yes, yes, no, no. So a lot of you are correct. It's a mix, right? So a lot of scenarios, often, unfortunately, some do and don't qualify. So let's break down Simone's scenario. So for Simone, it's yes and no. Yes, she qualifies for pregnancy disability leave, which is the job protection because she's pregnant and she works for an employer with 5 or plus employees. And it doesn't matter how long you've worked there, it's just that you have worked for an employer, 5 or more employees, and that you're a pregnant worker. And pregnancy disability leave typically lasts 4 weeks before your estimated due date and 6 to 8 weeks after an uncomplicated pregnancy. She can receive partial wage replacement for pregnancy disability leave through state disability insurance because she pays into it. And yes, she qualifies for paid family for bonding because she pays into the state disability insurance fund. So the same fund, but 2 separate leaves. The unfortunate part, though, is that she does not qualify for job protection. So that's the no part. She only meets 2 of the 3 requirements for job protection, which is that she does work for an employer with 5 or more employees. She has worked for an employer for more than 1 year, but unfortunately, she has not worked enough hours. She's only worked 1,040 hours in the past year, which is fewer than the requirement. But let's see how all of these work together. And just a reminder, as you see here, the eligibility requirements: 1 year at the job, 25 hours a week, 5 or more employees. So we're going to have 2 graphics here. The first one is we're going to start with a pregnant worker who's not eligible for Cifra, the job protection part, and then we'll talk about someone who is. As you see here again at the top part, it's the green for wage replacement for disability insurance and paid family leave. The bottom part is job protection. So we're going to start with the pregnancy disability leave part, right? So it's 4 weeks for pregnancy prior to the estimated due date, 6 to 8 weeks to recover, depending if it's an uncomplicated pregnancy. And during this time, this is the pregnancy disability leave. She'll have that job protection, and she will also receive 60 or 70% of her wages during this time. Then she will switch to paid family leave. Sorry, my phone is ringing. Hang on. Katie, do you mind just taking over real quick while I just turn off the phone? I'm so sorry.
Sure, yeah. So I think the main thing to know is that this worker qualifies for job protection and wage replacement for pregnancy disability leave. This person qualifies for wage replacement for paid family leave, but unfortunately does not qualify for job protection for bonding leave. So it's really up to them. They can ask their employer. Their employer is not legally required to accommodate their request, but might do so. And so it's really kind of up to their relationship with their employer and how supportive their employer is of their leave request. And Charlotte, if there's anything you want to add, go for it.
I think that's good. Sorry, everyone. I'm at my mom's house and she has a regular phone like we all did back in the day. So no, that was so great, Katie. Thank you. I didn't know also, Aditi, if you had anything to add. And I know next week we're going to be kind of covering the communication part with the employer, but I didn't know if you had anything to add to this graphic.
I don't, nope, nothing to add. That was great.
Great. So on the next slide, quite similar, right? Like what Katie was explaining and what we were talking about. It's quite similar with the PDL and then California Rights Act. But this time, if a pregnant worker is eligible for Cifra, she will have that job protective 12 weeks. So again, 4 weeks prior to the estimated due date, 6 to 8 weeks to recover. This is pregnancy disability leave. Your wage replacement will state disability insurance. And then now you'll transition to paid family leave right after your pregnancy disability leave. And next week, we're going to talk about how to file that claim and then how you'll automatically transition to paid family leave. And then you'll transition to the California Rights Act. And again, if you see at the end of the 8 weeks, there's that 4 weeks of unpaid, and that's really based on situationally. If financially you can take those 4 weeks of unpaid, you can. If not, go back to the job. But we just really wanted you to visualize how these jobs work together, or if someone's not eligible, what are other options of discussing with your employer. So with that being said, there are also other paid time off on the next slide. I'm going to hand it back to Aditi to talk about paid sick and safe days. Oh, I think you're still muted, Aditi.
You're right. Thank you. Gosh, a year in and I still can't figure that out. So I'm really glad that that we're talking about paid sick and safe days in this presentation. This is one area that people need all the time. People get sick all the time. People's kids and loved ones get sick all the time. And it's, even though it should be a very easy to figure out law, it's really not. It's pretty complicated. And so I'm glad we're covering it here. So every employee in California gets 3 paid sick days a year if you work 30 or more days in that year. Paid sick days can be used for your own illness or to care for a family member. And this includes diagnosis, care, treatment for an existing health condition, or preventative care like annual checkups. So you can use sick days for a doctor's appointment, a dentist appointment, a medical test. It can be used for all of those. It can also be used to care for someone else. If your spouse is sick, your kid is sick, you can take a paid sick day to care for them. And then something that many people don't know is that paid sick days can also be used as paid safe days, which is when you take time to seek care or services related to domestic violence, intimate partner violence, sexual assault, rape, stalking. This means that you can use a paid sick day to go to a rape crisis center or go to court to get a restraining order. You can use your sick days for all of that. So what you get for paid sick and paid safe days are 100% of your regular pay. You get job protection, meaning that you cannot be fired. If you have worked for your employer for at least 90 days total and worked in California for 30 days. Your employer cannot tell you, your employer can tell you how much time you have if you're not sure. There are sort of 2 different ways to do paid sick days. Sometimes you accrue it per pay period. That's how mine works. I accrue like an hour per pay period. And that's kind of the typical way to do it. But some employers allocate all of the paid sick days at the beginning of the year. So some people have all 3 of their paid sick days on January 1st. So if you're not sure how your employer does it or not sure how many paid sick days you have, you can just ask your employer. They should be keeping track. Employers cannot deny request for paid sick days. And you don't have to say why you're taking the paid sick day. You just say, I need to take a paid sick day. You should notify your employer as soon as possible. If it's scheduled ahead of time, if it's something like a doctor's appointment or you know that it's coming up, notify your employer that you need to take a paid sick day. Obviously, paid sick days arise because of emergencies as well. And so it's just notify as soon as you can. Your employer cannot require you to find a coworker to cover your absence as a condition of using leave. This is a thing we see all the time, right? With workers that a policy will say before you can't take a paid sick day unless you can find someone to cover. It's okay for an employer to have that policy, but if you cannot find someone to cover, you still get to take your paid sick day. That is your right. That is the law. Your employer cannot say you only get to take a paid sick day if you find someone to cover. They also can't retaliate against you if you can't find someone to cover. So you also don't need a doctor's note if you're only taking 1 day or 2 days, but if you're taking 3 days or more days, if your employer provides more days, then they are allowed to require a doctor's note. You can decide how much paid sick day to use at once. You can use your paid sick day intermittently. You can use like 2 hours to go to a doctor's appointment, or half a day because your kid was sick for half a day, or a full day. Your employer can't say if you take a paid sick day, you have to take a day. But your employer can require you to take at least 2 hours. So when COVID happened, the federal, state, and several local governments in California gave extra paid sick days to deal with COVID-19. The really important thing, and I think kind of the confusing thing to know about this paid sick day, is that it is only related to COVID-19. If you get sick for something else, this paid sick day does not apply to you. But it is nice to have if you need it for COVID-19. So you could take the supplemental COVID paid sick days to care for yourself if you have COVID-19, to care for yourself if you have to quarantine or a healthcare provider tells you to stay home, to stay home if you have COVID-19 symptoms, whether you are testing positive or not. If you are if you feel like you have the symptoms, then you can use this paid sick day. You can use it to care for a family member who has symptoms or who's in quarantine or whose healthcare provider told them to stay home. You can use it to care for a child whose school or place of care, like a daycare center, is closed due to COVID-19. You can use it if you are getting the vaccine or if you have symptoms related to the vaccine. And you get COVID-19 supplemental paid sick leave if your employer has 25 or more employees. You get 2 weeks of COVID-19 paid sick leave. It's retroactive to January 1st. So this is a little complicated, but essentially the law was passed on March 29th. So from January 1st to March 29th, this law didn't exist, but they made it retroactive, saying that let's say you took 10 days of COVID-19, you were sick for 10 days with COVID-19 in February, you can go back to your employer and say, remember that paid sick leave I took, that was actually because of COVID or because of quarantine or because I was caring for someone who had COVID. So you need to pay me for that time off. Most laws aren't retroactive. So this is a really unique thing they did to make it retroactive to January 1st. And it will end on September 30th of this year. There were also a lot of people who needed to take COVID-19 paid sick leave last year in 2020. There was a separate law that provided for that leave last year. Because sick leave resets every year, even if you took your 2 weeks last year, you get an additional 2 weeks for this year. And all of this is in addition to your regular 3 paid sick days that you already get in California. I believe that's it. So I'm going to pass it back to Charlotte.
Thanks, Aditi. So let's do a couple poll questions about the paid sick and safe days. So the first poll question, true or false, you can use paid sick and safe days for preventative care or seek care for domestic violence prevention services. So Katie, if you want to launch the poll.
All right, so everyone should be able to see this. We'll give you about 30 seconds to take your best guess of what you think. There are no wrong answers. We just kind of want to get a sense of what people think about this. So we'll give you another 10 seconds to answer the poll. All right, I'm going to end the poll. Mia or Jenya, are you able to see these results and just read them out for us?
I can see them. So mostly true, 95% responded true, 1 person responded false. Thanks for participating, all of you. Let's go see what the answer is. True. Charlotte, I'll pass it back to you.
All right. So yeah, great. Good job. So yes, true. You can use paid sick and safe days for preventative care. So if you need to go get a vaccine or to seek domestic violence prevention services. And then let's do one more poll. So true or false, paid sick and safe days do not offer job protection. Employers can legally deny you paid sick and safe days.
All right, so we are launching the poll now. Again, we'll give you about 30 seconds to fill this out. All right, take 10 more seconds. This is your last chance. No wrong answers. We won't share these results with anyone. Just want to get a read of what people think. All right, I'm going to end the poll and share the results.
Awesome. So everyone who participated said false.
Great job. So as Aditi mentioned, it is false. So paid sick and safe days do carry job protection. To qualify, you must have been employed for at least 90 days, worked in California for 30 days, and accrued the amount of time needed to take the leave. And employers cannot legally deny you requests for paid sick and safe days. And there's multiple ways to ensure your rights. Talk to your doctor or medical provider, talk to your employer, look at the EDD department. They have a lot of information there, and document all your communication. We're going to talk about this a little bit more in depth next week. Aditi and I will cover a new resources that we're creating regarding how to communicate with your employer. But Aditi, I didn't know if you had anything else to add to this slide.
No, I don't, but excited to talk about it next week.
Great. And we do have sample letters. Legal Aid at Work, who is also part of the coalition, has many great sample letters that individuals can download and has instructions how to fill it out. And we will also go over that next week, but it will be in our resources at the end of these presentation slides. And one of our resources that we're still developing and will be launching soon, but we thought we would just go through it with you today, is our paid family leave checklist. So for our paid family leave checklist, we're going to go through a scenario. Again, so this is Naomi and Tiana. They're expecting their first baby. Tiana is 25 weeks pregnant, and she wants to know what her and Naomi's rights are to take leave to bond with their new baby. Naomi has worked at her job full-time for 40 hours a week for her employer for the past 5 years and has about 20 coworkers. Tiana has worked 30 hours a week at her job for the past 2 years and has about 60 coworkers. Both of them pay into the state disability insurance. So let's break down the couple's scenario. So we're going to start with Tiana first, and she will be taking leave first for pregnancy disability leave. So Tiana is pregnant, so she needs to see if she meets the eligibility requirements for pregnancy disability leave, so the job protection and state disability insurance, which is the wage replacement. So when you're working with a new mama, some things to consider is that, does she qualify for pregnancy disability leave, and does she qualify for state disability insurance? So for Tiana's case, yes, she meets the eligibility requirements for pregnancy disability leave because she's pregnant and works for an employer with 5 or plus employees. Yes, she meets the eligibility requirements for state disability insurance because she does pay into the fund. And if she has an uncomplicated pregnancy and birth, she will likely take 4 weeks of job protected time off before and then 6 to 8 weeks after giving birth. And she can receive 60 or 80% of her wages while on leave through the state disability insurance fund. So now that we know Tiana's pregnancy disability leave, let's check out Naomi's leave. So since she is the non-birthing parent, we will focus on the bonding leave part. And this is where the checklist comes in. And this checklist, really, the questions are based on eligibility. So let's start with the first one. Why are you using time off? And check one below. So are you going to bond as a birth parent with a child born within the past 12 months? Bond as a non-birth parent born within the past 12 months? Bond with a child adopted within the past 12 months? Bond with a foster child placed in your home in the past 12 months? Or care for a seriously ill family member? In this case, it would be bond as a non-birth parent. And then, have you worked at your job for at least 1 year? Yes, she has. Have you worked at your job for at least 1,250 hours or approximately 25 hours a week? Yes. Does your workplace have 5 or more employees? Yes. And do you pay into the California State Disability Insurance? Yes. And then the final question is, do you work in the city of San Francisco? And this is a bit specific as their ordinances are stronger. And Aditi, I was wondering maybe if you could explain that one a little more and why we have that question.
Yes, absolutely. So there's this in the city of San Francisco, there is a separate paid family leave ordinance that actually covers, so, as we talked about, the state will cover 60% or 70%. In San Francisco, the government requires employers to top that off. And so to pay the remainder of the 30% or 40%. And so we have this here so that if someone checks, yes, I work in the city of San Francisco, the ultimate response is not only do you get 60% or 70% from the state EDD, but in addition to that, you get 30% or 40% from your employer.
Thanks, Aditi. So again, the eligibility requirements for Cipra: 1 year in the job, 25 hours a week, and works an employer 5 or more employees. So based on the checklist for Naomi, her rights is that she does qualify for paid family leave for bonding and job protection. She pays into the state disability insurance fund and would receive 60 or 70% of her wages up to 8 weeks. Unfortunately, she does not live in the city of San Francisco, so it will just be focused on the state disability insurance fund. She works for an employer with 20 or more employees and has been an employer for more than a year and has worked about 2,080 hours, which is more than the requirement. So that means she can take up to 12 weeks of job protected time off. So now let's look at Tiana's bonding leave. Again, we're going to use a checklist. So for this one, why are you using the time off? She is using it to bond as a birth parent with the child born within the past 12 months. She has worked at her job for 1 year. So yes, have you worked at your job for at least 1,250 hours? Yes. Do you work at a workplace with 5 or more employees? Yes. Do you pay into the California Disability Insurance? Yes. And then she does not, unfortunately, live in the city of San Francisco. So based on the checklist, she can use paid family leave and can receive up to 8 weeks of partial wage replacement. And she does meet the requirements for job protection and can take up to 12 weeks of unpaid job protective leave to bond with her baby. So let's put all of this together. I do want to say each scenario is different, but again, we just want to help you visualize how a partner and a birthing parent would take this time off and how this would kind of flow. So week 1, let's say Tiana is going to take her pregnancy disability leave 4 weeks prior to her expected due date. After talking with her medical provider, that's when her PDL will start. 4 weeks later, she had a C-section, and then that her PDL at this point will continue. So the 4 weeks before and then 6 to 8 weeks after, she will be recovering and continue on pregnancy disability leave. When she gave birth, that's when Naomi decided to start her bonding leave. So for the next 8 weeks, Naomi will be on her bonding leave. So now we see at week 12, Tiana's pregnancy disability leave ends, and then she will automatically start the bonding leave. And then now Naomi's bonding leave ends. I do want to set a reminder that Naomi does have the 4 extra weeks of the unpaid job protected time off, but again, it's situationally based, considering finances, considering each situation. But for this situation, Naomi is going to go back to her job while Tiana continues on leave for bonding. And then at week 24, Tiana's bonding leave would end. Again, this is situationally based. Their PDL might extend, right, depending if there's postpartum issues that her doctor would consider that she would need to extend her pregnancy disability leave. But this essentially is just a timeline of how 2 parents would take time off as a birthing and non-birthing parent. Aditi, I don't know if you have anything to add to this.
Nope, nothing to add. This looks great.
Great. And then to wrap it all up, so Tiana and Naomi did decide to take time off as they receive both wage replacement and job protection. And both of them can choose to take the additional 4 weeks of job protected unpaid time off to bond with their baby. So when you work with parents, it's just being open and honest that they just need to consider, is the 60 or 70% able to keep up with their finances. And then if the unpaid time off is good for them, it's still their right, but it's really their choice to take that time off. So that is the scenario. I hope that was helpful to put all of this together. So now it's time for some Q&A session. So you can unmute yourself. I saw some questions in the chat, so I'm going to go back and check it out. Unless Jenya, you saved them, but go ahead and unmute yourself, put it in the chat.
Yeah. I think, definitely, Charlotte, go back and look, but 2 that stood out that I was wondering if Aditi, Charlotte, others could help with are, one was really good just about enforcement around the lactation accommodation laws that I saw you answered, Aditi, but I thought maybe other people might have questions, because I do think enforcement, when you're at that point and your employer, what if your employer is saying, no, you don't have this right? Many times they're actually misinformed, frankly. What are your options? I think that's a really great question. And another one that Joycelyn, I think, brought up was about federal laws. Let's say you're a letter carrier, that you live in California. What of these laws, impact you? Because I know we have different federal laws. So those were 2, and there may be more.
I can start, but if anyone has anything to add, please feel free to interrupt. So both are such excellent questions. So for the lactation accommodations, yes, you are absolutely right that this law is very poorly enforced. Employers either don't know their obligations or know and aren't following it. Their obligations are also changed recently. This is sort of a fairly new, the obligation to have a sink and refrigerator, a place to sit, a surface, that is all new as of January 1st of last year. So it's also very possible that employers don't know that they have new obligations now that they needed to incorporate. And so I guess there's two things that I'll say as far as enforcement goes. The California government office that handles enforcement is the Department of Labor. They collect complaints on lactation accommodations and will conduct investigations and can fine per violation. So if you want to submit a complaint directly to the government, if you Google sort of Department of Labor, California Department of Labor, file a claim, that link will take you there. And also, I think I put my email in the chat. I will say that I write more demand letters on lactation accommodations than anything else. I think that employers really do not know what they're required to do. So if you sort of want to either know your rights and just clarify that you do have these rights at work, or you would like someone to write a demand to your employer, please feel free to email me. I would love to do that. The other thing, I feel like one more thing to say on lactation accommodations. Yes. So there is, I think that you put this actually in your comment, which is absolutely true, that there's a different requirement for employers for smaller employers. However, that's only if they face an undue hardship. And I think a lot of employers don't know that. They have to be under 50 employees and face an undue hardship. That's kind of hard to meet. I mean, an undue hardship really means that your work situation is just absolutely not conducive to having a room for you to pump in. Most places are conducive to that. Most places there's a break room or there's an extra room that can be temporarily turned into a lactation room. And so it's both. They have to be under 50 employees and can prove that they have an undue hardship. And then for the question on federal employees, that's such a great question. And your instinct is right that a different set of laws applies to federal employees. In the realm of sick laws, the law is actually better for federal employees. Federal employees get 13 paid sick days a year. And for COVID-19, they get 15 weeks to deal with a COVID symptom. It's called paid leave. So I think it's both paid sick and family leave combined into one. So federal employees are actually, for example, if you work for USPS, which is I think the example that you gave, federal employees are better positioned. They get 13 paid sick days, but an entirely separate set of laws and eligibility requirements apply to them than what we were talking about here today.
And Aditi, I think there was a follow-up question regarding the undue hardship part. Is it somewhere in the law that we can see it?
Well, it's not defined in the law. So yes, it's in the law. The phrase undue hardship is in the law. It is what an undue hardship is not defined, unfortunately. And there may possibly no cases yet on what exactly, like where that delineation is. And so yes, but the employer kind of needs to be able to prove to the Department of Industrial Relations that that their particular situation is just so outrageous, so different, so unique that it would that it would be an undue hardship.
Okay, I think let's look. There was another question. When should expecting families start looking into this during pregnancy? Aditi, I don't know if you want to take this, but I feel like for me, when I've heard some of this, is really talk to your medical provider as you're coming along, see when your expected due date. Some pregnancies do tend to be complicated, so it really is situationally based. But as long as you're going along and your pregnancy is going well and you're planning for this, it's great to just start knowing your rights as soon as possible for you and your partner and your family, because you do want to notify your employer at least 30 days prior to you taking leave. And depending on your relationship with your employer, sometimes you do want to have that conversation and plan for this time off. So maybe as soon as possible, when you're along with your pregnancy, you've had your conversation with your medical provider as the estimated due date, get to know your rights for you as a birthing parent and non-birthing parent, and try to begin to plan it. That's such a great question, because we're going to go into detail with that next week and kind of just think about the process of that. Aditi, I don't know, or Katie or Jenya, anything to add to that? And then another question is that, can COVID supplemental paid sick leave be used for children doing distance learning and parents who have their hours reduced to accommodate? Aditi, I'm going to pass that one to you, if that's okay.
So I think that we would say yes, though I think the true answer is really tricky about what is accommodation and all of the stuff that we could get into sort of to the weeds of. But I think that I think we would say yes, because the spirit of the law is that you get to use these 2 weeks when when your kid's school or daycare is closed. And the idea is that means that you have to take time off. It doesn't say anything about distance learning and having to use, hours to actually educate your child. Like that's not within the law itself, but we would argue that that is kind of what the spirit of the law is getting at. So we would say yes. We don't know kind of how it's playing out in real life, if employers are pushing back on this or not. And then for the second question of, if so, can parents request retroactive supplemental pay? The answer to that is yes.
Great. I realize it's 59. We're there's resources in the slides regarding the supplemental paid sick leave as well. I'm going to hand it to Mia to talk about our advocacy day before we end. And if you have more questions, we have one more training next week. So definitely save it for next week as well.
Thanks, Charlotte. So as Charlotte mentioned, we have a bunch of resources that she's going to send to you in an email. So look out for those. And we wanted to make sure everyone knows about our Paid Sick and Safe Days Advocacy Day that's happening on Friday, May 21st from 10 to 1:30. You don't have to go for the whole thing, but essentially what this is we are going to be meeting as a group with lawmakers to talk specifically about Assembly Bill 995, which would increase our Paid Sick and Safe Days from the 3 days to 5 days. So if this issue really matters to you, if you want more paid sick and safe days to have the right to use, definitely consider signing up for our advocacy day. You can go, Charlotte will send the link, but you can go to our website to sign up there. And I think it's just easier to send you a link because it's kind of a long URL. But yes, we would love to have you there, and you can get to know other people who have, the same passions and desires to fix the law as you do. And also it's just a great way to get introduced to advocacy and learn about your power in using your voice in improving the laws.
Yes, definitely. We hope to see you there. And then as it is 11 for next week, we also hope to see you next week for our final training. We're going to go ahead and how to file a claim, talk about how to file a claim, how to communicate with your employer, and practice scenarios. Mia, real quick, if you had the link, do you think you could put it in the chat? I think some people are really interested.
I'm trying to grab it right now, but if one of Katie or Angelica could snag it, that might be easier.
All right. But yes, if you could join us next week, we'll put that in the chat now. Next week, we're going to go into how to file a claim, communicate with your employer, and kind of put everything together next week. And then I think that's really it. No worries, Mia. I know you're trying.
Paying attention to that.
Sorry. But that's it for us this week. We hope to see you Friday. Definitely, we need people to advocate for these laws. And we hope you enjoyed today. We'll be sending out the slides, and I think also Naisha will send out. We have recorded this, but we hope to see you next week at the same time. And thanks for joining us today.
Thank you, everybody. And
thank you, California Working Family Coalition, and thank you, Aditi from ACLU, for joining us and bringing this powerful information to the can of the public start. I'm really thankful. So thank you so much. Thank you, everyone, for coming. Hopefully we'll see you all next week.
Thank you, everyone.